I am just delighted to have our own Maureen Brooks, our resident attorney, opera queen, teacher of Ollie classes, many and goer to Ollie classes, who has specialized in all things judicial, and was nice enough to do a class for us on the Constitution. She's here today to talk about the ERA in Arizona and see if she can get enough of us jazzed up to be the final state that's needed to make this a possibility across the country. So with that, Maureen, the stage is yours.
Take it away.
Okay.
Welcome, now that I've got it going. I do need to say that I'm no constitutional scholar, but I am fascinated by the Constitution and certainly the ERA. So what's happening now, and I'll go into this somewhat as we go through it, but what's happening now is theoretically, I'm not entirely sure of this, but theoretically, only one more state is needed in order to make this another amendment to the Constitution, of which we already have 27. So this is the entirety of the Equal Rights Amendment. There's some parts of it that essentially say how it's going to go, but that's all procedural stuff. This is exactly what it says. It's not complicated, doesn't have reams of rules and regulations at all. This is what it says. 72 to 80% of Americans think the Constitution already guarantees women equality. So the history of it is very interesting. It was introduced in the U.S. Congress in 1921, reintroduced by U.S. Representative Martha Griffiths of Michigan in 1971, was approved by the House of Representatives on October 12th of that year, and in 1972 it was approved by the U.S. Senate, thus submitting the ERA to the state legislatures for ratification as provided for in Article 5 of the Constitution. Per Article 5, once 3/4 of the states have ratified any proposed amendment, it automatically becomes an amendment to the Constitution. And it's important because at that point, neither the executive branch nor the legislative branch have any say about it all. There's no veto power. It's done. Although it may be subject to questions about constitutionality of the process or contents. So Article 5 basically says 3/4 of the several states, 3/4 of 50 states equals 37.5. So we round up to 38. So right now, theoretically, we have 37 states. The Constitution doesn't set any deadlines for passage of any amendment. Until 1919, Congress, in its resolutions to accept amendments, set no time limits on the passage of constitutional amendments. And then came along the 18th Amendment, which was prohibition. It was the first to specify a deadline for ratification. Up until then, there is no deadline. 3 subsequent amendments contained a deadline in their text, but others set no deadline at all. So this was unusual. Part of the reason they did it, starting with the 18th Amendment, is that they sort of hoped that all, I don't know how many states there were at the time, and we had Arizona, but we didn't have the others, so it was probably 48. So 3/4 of 48. They basically, I think, hoped that it wouldn't pass because prohibition was a little iffy, but it did pass. So then in 1921, the 19th Amendment went to the Supreme Court to find out if that ratification was, if the restriction on it was valid. And they said that the fair interference or implication from Article 5 is that the ratification must be within some reasonable time after the proposal. So, the court continued, amendments are to be proposed, the reasonable implication being that when proposed, they're to be considered and disposed of presently. However, the court didn't require Congress to put an expiration date on amendments to be ratified by the states. It only confirmed Congress's power to do so. That's an important legal distinction. Since 1951, the time limitation has been included in the resolution proposing the amendment, whatever amendments there were after 1951, rather than in the amendment itself. Traditionally, 7 years has been the maximum time allowed. That's according to the Guide to Congress, but that's not set in stone. Congress had originally set a ratification deadline of March 22, 1979 for the state legislators to consider the ERA. Through 1977, the amendment had received 35 of the necessary 38 ratifications. So then, the deadline was extended by Congress to 1982. They did not have any other states since that extension. No other states signed on to it. Okay. Now, I'm bringing up the 27th Amendment for a reason. The 27th Amendment says no law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. This particular amendment was first proposed in 1789, okay? But it took 200 years and a campaign by a Texas University student, it's a fascinating story, before it was finally ratified in 1992. Okay, so all but just 6 states back in 1789, or 1792, which was the deadline, they needed 7 out of 13 states, and they couldn't get 7. So anyway, it languished, nothing happened to it for all those years. So suddenly people thought this was a splendid idea, so the state legislatures did go ahead and ratify it, and the 27th Amendment became part of the Constitution. But Congress, because it was 200 years ago, and they said, what the hell, how did this happen? Some leaders questioned the legality because it had taken such a long time. In the meantime, the Archivist of the United States certified the amendment as ratified under Article 5 of the Constitution. That just means that he did it. It doesn't have any legal effect. Congress then voiced its own support of the 27th Amendment in a near unanimous vote. And since 1992, the 27th Amendment has gotten very little publicity. In 2014, during the fight in Congress over the federal government's budget, and more recently, this December with the shutdown, GOP House leaders proposed and various other people, proposed linking congressional pay to the budget debate. So if you've ever heard of this, people said, well, why don't we just, they shouldn't be paid anything if they're going to shut down. We can't do it because of the 27th Amendment, okay? So that's just an aside. But with wide bipartisan support, the ERA seemed destined for ratification until Phyllis Schlafly mobilized conservative women in opposition. These arguments were that the ERA would disadvantage housewives. This goes back, remember, to the late 70s, early 80s, cause women to be drafted into the military. We still had a draft, we don't have that now, and to lose protections such as alimony. Well, we now have alimony that go both ways. And eliminate the tendency for mothers to obtain custody over their children in divorce cases. That's a whole other issue. Family law is basically based upon property law, because wives and children were property. So that really is a different animal altogether. Labor feminists, and this is true, also oppose the ERA on the basis that it would eliminate protections for women in labor laws. So it was extended from 1979, 35 states had ratified. As of the 1982, still only 35 of the necessary 38. But then what happened, then there was a number of states, 15 out of the 15 states did not ratify at all. That includes Arizona, various other states, which I listed here. But then 5 states along the way who had voted for it, the state legislatures rescinded their ratification of the ERA amendment, okay? So this is a big question, whether or not those rescissions are going to be valid or not, okay? The 5 states included Nebraska in 1973, Tennessee, 1974, Idaho, 1977, Kentucky, 78, South Dakota, 79. So that was even before the extension occurred. So it's not clear. Nobody ever looked at it or wanted to deal with it, I think. So anyway, here are the 35 states that ratified the ERA, and various of the 35, 1, 2, 3, 4, 5, have rescinded that ratification. So that's sort of up in the air, an open legal question. So some of the questions now that are coming up with legal scholars are, were the deadlines imposed by Congress in 1972 to 1979, and then in 1979 to 1982, were they constitutional? So that's sort of an open question. Nobody's answered that definitively, but there are various case law that by the Supreme Court that suggests that it would be okay, including the 27th Amendment, which took 200 years essentially without a deadline. And even though the idea was that it should be a rational amount of time, that's 200 years. So that's up in the air. And secondly, were the rescissions by some of the original 35 who ratified the ERA, were they constitutional? Open questions, nobody knows. However, your answer or the legal scholars come down on either of these questions, this is not an idea that I'm suggesting that we should not try for the ERA. That's not at all what I'm suggesting. But I've been to at least one presentation that the woman was relatively sanguine about, oh, these are not issues at all. And I think they are, and I think they'll be argued for some time. Again, doesn't mean that we shouldn't try for it. We need an Equal Rights Amendment. People say, well, why do we need an Equal Rights Amendment? Why do we need it? We have a lot of laws that protect women now and that suggest that there's equality. The idea is that it needs to be in the Constitution itself, because that is the highest law of the land. So I'll go into that a little, oh dear. So it's needed to constitutionally affirm that the bedrock principles of our democracy, which state in the Constitution, all men are created equal, liberty and justice for all, equal justice under law, government of the people, by the people, and for the people, that they apply equally to men and to women in the United States of America. That's not been definitively stated by anyone. Ruth Bader Ginsburg, I have to quote my Ruth, the equality principle is not in the original Constitution. The Equal Protection Clause shows up in the 14th Amendment, she believes. However, Justice Scalia, when he was alive, thought the opposite. He thought that the 14th Amendment specifically did not include women. So we have an issue there. The best reason that, according to her, the best reason is if you look at any constitution that's been written since 1950, you will find it in a statement that men and women are equal before the law. So she goes on to say she has 3 granddaughters. She'd like to be able to take out her pocket constitution. Do we all have our pocket constitutions? Yeah. All right, I certainly do. Okay, so that's one of the statement of why it's important. Legally, there's some very specific things. The ERA would clarify the legal status of sex discrimination for the courts. For the first time, sex would be considered a suspect classification, as race and national origin are, and I'll explain why that's important in just a minute. Government actions, this all relates to government actions, that treat males or females differently as a class would be subject to strict judicial scrutiny. That's very important. It's an important constitutional issue, and I'll explain it more. Would have to meet the highest level of justification. And the other, I'll explain this in a minute, but it also means that the burden of proof when an issue goes to court, if it's under strict judicial scrutiny, the burden of proof to prove that it meets the constitutional standard would be on the government that is making those laws. Right now, the burden of proof is on the person, whoever it is, that, because it's a rational basis, not a strict scrutiny. You don't have to remember these terms. I'm just trying to explain them to you why it's legally important. Under a rational basis, which is what most of the laws are now, it means that the burden of proof is on the person who brings the action. It's a huge difference. It's a huge difference, legally. And then it would send a preemptive warning. I mean, that's all nice, but... okay, strict scrutiny, and there would have to be, the government would have to show that there's a necessary relation to a compelling state interest. The burden of proof is on whoever's making a law that does not have women equal to men. Okay, this is really tiny, but I tried to put a lot in it. So strict scrutiny is at the top. That's the highest level. When the courts look at laws, that's the highest level that they look at it for if it's in the Constitution. Otherwise, they can use either immediate scrutiny, or the lowest is rational basis. So if there's some rational basis, according to the courts, for a government to put through a law that winds up being discriminatory against whoever, men, women, whatever, races, whatever, the rational basis is a very easy test to pass. And courts always, pretty much always, sort of bend over backwards to find for the government if it's only at the rational basis level. If it's in the Constitution, it's therefore at the strict scrutiny level, a very high level. The government has to affirmatively show that what they are doing is not discriminatory against whoever's in the Constitution. The first and still the only right that the U.S. Constitution specifically affirms equally for women and men is the right to vote, right? And that was the 18th Amendment. The ERA would provide a clearer judicial standard for deciding cases of sex discrimination. Federal and state courts are inconsistent in their rulings, and it would also effectively invalidate the claim of late Supreme Court Justice Antonin Scalia and all of his cohorts who believe as he does in originalism and all of those things with respect to a very, very restrictive view of the Constitution. It would say essentially to all of them, doesn't matter whether the 14th Amendment does or does not cover women, as they can argue about. It would be specifically an amendment in the Constitution, and that just precludes this argument. It's just not important. Without the ERA, women regularly and occasionally men, as all of us who have seen Ruth Bader Ginsburg's The documentary, etc., she was very, very savvy about bringing cases on behalf of men who were not treated equally. And all of the male justices were like, well, that's just awful. And she was very smart to do that because it created that bedrock. Also, the ERA would improve the United States' standing in the world community with respect to human rights. The governing documents of many other countries affirm legal gender equality, mainly at the insistence of the United States government. Which is fascinating. Okay, so now we move on to Arizona. I should say, by the way, that assuming that the ERA, the arguments don't hold water, that the states can rescind having previously voted for it, and assume that we now have 37 states, and that's true, Nevada and Illinois, have brought it up to 37 states. One more state, theoretically, if there's no issue about the rescissions, one more state can put it over into the 38 that's necessary, okay? That's assuming all kinds of things. I'll get into it later on, but both Virginia and North Carolina have been looked at recently as being the most likely, and I'll explain a little bit to you why that's becoming increasingly problematic. So the Arizona Constitution is quite fascinating because it was established in 1912. Arizona was really quite a progressive state at the time. Many of the Western states are the ones that first had women voting and first sent women to Congress. You know, they basically, as a generalization, the Western states sort of believed, you know, if you can do it, you know, we don't care if you're, you know, whatever. So in Section 13 of the U.S. Constitution, no law shall be enacted. This applies to the state of Arizona, and it is, the U.S. Constitution is sort of the floor below which you cannot go. Each state constitution can say whatever they want, which add rights to the U.S. Constitution in effect. So the Arizona Constitution, no law shall be enacted granting to any citizen, class of citizens, or corporation other than municipal privileges or immunities, which upon the same terms shall not equally belong to all citizens or corporations. The corporations thing's kind of interesting recently. Qualification of voters, Section 2, no person shall be entitled to vote unless such person be a citizen of the United States of the age of 18 years or over. The word citizen shall include persons of the male and female sex. That's in the U.S. Constitution, not in the Arizona Constitution. Section 2 goes on, that was A. Now B, the rights of citizens of the United States to vote and hold office shall not be denied or abridged by the state on account of sex, and the right to register to vote and to hold office under any law now in effect or which may hereafter be enacted is hereby extended to and conferred upon males and females alike. So this is 6 years before the 18th Amendment. Can I do 8 years before the 18th Amendment? Section 6, university and all other state educational institutions shall be open to students of both sexes. They do have Article 30, which talks about marriage as being only a union of one man and one woman shall be valid or recognized. But again, the base level of what rights are available is the Constitution and cases describing it. The state constitutions cannot be lower than what the U.S. Constitution provides. So that's now irrelevant. In 1972, Republican State Senator Sandra Day O'Connor introduces the ERA, was passed by the Arizona Senate, blocked in the Arizona House, which was protested by Arizona Republican Sister Claire Dunn. This is a Catholic nun who was one of the first Catholic nuns to be actually a representative. It's just kind of interesting. Since 1982, the ratification of ERA amendment was brought or proposed yearly to the Arizona Senate and House, but it was never brought to a vote on the floor. And as we all know, it doesn't matter if it's proposed in various committees. It has to get to the floor of the House and the Senate in order for there to be a vote. The people in charge have never allowed it to actually get to the floor of either the House or the Arizona Senate in order to vote on the ERA. Presently, it's a Republican-controlled state Senate and House of Representatives. The state House and state Senate committees through which proposed legislation must pass were and are controlled by opponents to the ERA, outright, out-and-out opponents. The most recent bill, House something, I don't know what, to 2012, which was this year, to ratify it was proposed in 2017, was introduced by Arizona Representative Pamela Howard-Hanley on January 23rd, 2017. On April 27, when she made a motion for the House to consider her bill, Speaker J.D. Mesnard proposed the House go into recess, which would effectively table the bill. The motion to recess was approved by the legislators by 32 in favor of 5 against, and the whole thing went away. It was a procedural thing that they managed to get around. The ERA bill would have had a hearing in the House Committee on the Judiciary and Public Safety. However, an article by Howard Fisher Capital Media Services, that's the source, indicates that Representative Hetty Farnsworth a name known and loved by all of us. The chair of that committee was unlikely to provide a hearing. Farnsworth argued that the state law already outlaws gender discrimination and also contended that the bill could have unintended consequences, including a potential for women to be subject to the draft. This is 2017. We don't have a draft. Since the 1970s, legislators in the Arizona State House, whether in the House or Senate, have avoided calling the Equal Rights Amendment for a vote on the floor. So now, what you can do is contact Senator Karen Fann, president of the Arizona State Senate from Prescott, and ask her to submit the ERA proposal to a friendly committee. She will choose the committee. Last year it was sent to a committee whose chair refused to act. She has been approached and needs some help to make the right decision. Her phone number is 602-926-5874. Her email is kfann, F-A-N-N, @azleg.gov. And basically what you want to suggest to her is that in no case should it be assigned to the Judiciary Committee, where Senator Eddie Farnsworth, who is Senator Fann's second in command, has vowed to kill it. First choice would be the Commerce Committee. It's chaired by Senator Uhenti Rita, I think. I'm not very good at this. He or she is a co-signer of the bill. Vice Chair is Senator Tyler Pace. Traditionally, bills are assigned when possible to the committee of the sponsor. So this action has precedent and should provide the utmost support for getting, this would be the Senate version of the Equal Rights Amendment, Senate's SCR 1006, to full vote. Supporters also conclude that ERA's impacts on the economy and workforce make it a natural choice to place it under commerce in the Arizona legislature. Second choice would be Health and Human Services. SCR 1006 signer Senator Heather Carter is vice chair, and the chair is an ERA supporter. So that would be like a second choice. Third choice would be the Government Committee. Chair Senator David Farnsworth. They're both opposed to the ERA, but Senator Farnsworth reportedly will at least talk, whatever that means. The Government Committee also reportedly has three strong Democrats to fight for the ERA, and there they are. So here's a suggested text for requests. You can do it whatever you want. In good faith and for equality among all Americans, please assign SCR 1006 to the Commerce Committee or Health and Services Committee, where it will have the opportunity for open and honest discussion and the potential of advancing. We must ensure equality for everyone under the U.S. Constitution so that rights cannot be given or taken away based upon political whims. The future of our families, society, and economic well-being is at stake, or something along those lines. Thank you in advance for your prompt attention to this matter. So, Virginia and North Carolina are the two that have been the focus of the national ERA proponents. Virginia seems to have one elected official after another who's being accused of something or another and told to step down, and we're getting down between the governor, the lieutenant governor, and now the attorney general. I don't know how far down the Virginia Constitution allows for whoever else would step up, but that's a real problem. In addition, the deadline for Virginia legislation for all new bills is February 23rd. So that's like a week away. So that's problematic. And of course in North Carolina, everything is held up there because there are allegations of fraud in North Carolina that are being investigated. So that's a mess. They can't even get their people together to figure out who should be representing them in the Congress. So that's all I have, and I thought I'd open it up to questions if there are any. I don't know how much time we have, but Can you give me an idea? How much time?
We're good on time.
We're good on time.
Yep.
So if there are any questions, I'll be happy to try and figure them out. I'm no constitutional scholar. Lois?
The 5 states that rescinded their initial approval, if they're included in the count to get to 38.
Right.
So if you get to 38, it seems to me there would be a challenge on the validity of that approval,
You bet.
and that would probably end up going to the Supreme Court.
Well, it would first go to each of the state legislatures to try and figure out if they want to hold with their original ratification. They could probably, push through another, and it's unclear if they can rescind it, and it's unclear if once rescinded, that they can just go back and reinstate it. I mean, it's just hasn't been, anything decided in the courts on that particular issue that I know about. I mean, there's probably some precedent somewhere, but it's not a reason not to go for it. That's not at all what I'm saying, but we should not be that sanguine to think that just on the off chance that Arizona's legislature decides to pass it, and that would be the 38th, that automatically it would become part of the Constitution. It would be a lot of constitutional and a lot of state issues, and, it may all be resolved. I'm not saying it won't be, but, yes.
Is the Constitution silent on anything about taking it back, revoking it, rescinding it? Is there any clause in there that
No.
refers to that?
No, there's no clause in it. The Article 5, if you read Article 5, it just says this is what it is. And there's no case law that I know of. I mean, I'm 40 years out of law school, and I no longer practice, and I love this stuff and I try to follow it, but I'm no constitutional scholar. As far as I know, there's no case law about that. The Constitution is a pretty spare bit of writing, and it's designed that way. If you get into the weeds and into all the, specifics of what you can and can't do, that sort of limits. Although then we have, Article 10 that says anything that hasn't been, already set aside goes to the states, so they can do sort of an overall thing. But yes.
So that 27th Amendment, when that occurred, that energized a lot of people, myself included. And I've had discussions with quite a few people that are opposed to the Equal Rights Amendment, but that's something that gets their attention.
Yeah, that's right. 200 years.
So is that a key point that we should be focusing on? Or, look, probably everybody in this room is active enough to want to talk to people. Is there something that you can give us that might be a legitimate talking point that we could use when we run into this, whether it's somebody that supports or not, just to be able to bring it up in conversation?
I don't know if I can be any more clear, other than that was 200 years. If there's a limit, there hadn't even been a limit until 1919. And, why there's a limit on it, who knows, but Congress was essentially told that they can sort of do whatever they want within certain structures under the case law that I told you about in 1921, which questioned the 19th Amendment. Prohibition. And but that 200 years is certainly impressive. And to be honest, that may be something to to talk with people about, but most people are not even aware of that. Most people seem to think that the Constitution and various laws already give equality to women, and that we shouldn't be fooling around with that. Oh, and also that it would open things up for abortion and that sort of a thing. And that's highly speculative. I mean, an equality amendment with respect to abortion, I don't know. I mean, that's, may or may not be relevant, but I can think of various attorneys that would use that, but it's not automatic. It's a very simple statement. I mean, it's very simple. You have another question?
Well,
Yeah?
just one more,
Yeah,
I'll
you can
stop
have
this,
as
but
many
you
as you want.
mentioned Scalia's.
And his
No,
cohorts.
And his cohorts,
Yes.
but you did mention him specifically. Are there any other current members of the court that have expressed the same viewpoint he has?
Not on that specifically,
Yeah.
but he was enunciating, I can't think of the name of the group, frankly. Pat, do you know the name of the group?
I know my name of the group.
Yeah, no, well, yes. No, the name of the group that basically espouses Scalia's view and Roberts and a whole bunch of them that have been,
The originalists, yeah.
well, the originalists, but there's a particular group that, that if you donate to them, you can, write it off on your,
The Federalist.
it's a C13, it's
Are you the Federalist Society?
maybe the Federalist Society would be, yeah. But that's sort of down the road, that's sort of down the road a bit. The real issue is getting it this year. I mean, I don't know, we have to do our best, because North Carolina is just crazy, and Virginia is even crazier maybe, but they have a week to get that all together and solve whatever's going on there, and get laws before the legislature there, so not likely. Henny?
Well, according to request to speak, it's already been assigned to the Judiciary Committee
Oh, okay.
at the end of, on January 28th. And
Oh, okay.
And it's also gone to the Rules Committee, and there's been no vote in either
Okay.
committee. So if there isn't a vote by the end of this week, that's it.
That's it.
In Virginia?
Here. Here.
In Arizona.
In Arizona, sorry, yeah.
Ollie?
I have a positive thing to say.
Oh, good.
Since this has begun to awaken people that do think we have the ERA at the national level, a whole lot more activity has been going on around this. If you read the literature, they've got billboards up, they're educating people all over the place. And having been aware of this for a couple of years myself and tracking it, I can say that we made a lot more noise in Phoenix this year than we've ever made, and we'll make more noise next year. On the one hand, on the other hand, my personal opinion is it's gonna take voting Democrats into leadership positions before we'll accomplish this.
Right, and there's some other positives too. I just read that the Mormon Church, I was gonna try and give the whole name, but I can't, Latter-day Saints, the Church of something of Latter-day Saints.
It's the Church of Jesus Christ of
The Church of Jesus Christ of Latter-day Saints has withdrawn their opposition to the ERA. They haven't,
Wow.
said that they're for it,
They have-
Oh.
but they've withdrawn their opposition. So, and that means something in Arizona. We have Snowflake and all those. Yes, Nancy?
The other states that I was looking at, there are a lot of southern states.
Oh, yeah.
Pretty conservative. There's no hope that any of them will ever get on board. Like Mississippi, Missouri. You haven't heard anything about it.
I haven't heard anything that sounds positive about them, no, with respect to anything, let alone the ERA.
But they don't have to wear burqas
So any other questions? Yes?
Could Nancy Pelosi be a contact person to move any of this forward?
No, it's entirely up to the state legislatures. It's entirely up to the state legislatures.
Disseminate information
It has
to people.
not, nah, that's, the direct route is much more important. I don't think she has that much clout. I don't know how much clout she has you know, in the House, she seems to have some clout, but on the other hand, there's, people seem to be going their own way, but she doesn't have any clout in state legislatures. There was another, yeah.
I didn't hear the woman up in front. What did you say about the end of this next week in Arizona?
The Arizona State Legislature has a deadline for when legislation can come out of committees to be voted on the floor, like the whole legislature. Sure. And so they have this week to get it out of committee, and then it's too late for this year.
So we need to email right away.
Yeah, right away.
Well, it's in the Judiciary Committee and in the Rules Committee, and unfortunately, the Judiciary Committee is the worst one, because it won't come out of there, I don't think.
So, you know, there you are. What, I was gonna say one other thing with respect to that. Lost it. Yeah, Lois.
Penny, just a clarification, if it's gone to 2 committees for review, do both of them have to agree to send it to the floor, or is it okay if just one agrees to send it to the floor?
Well, my understanding is Rules only gets involved once another committee has okayed some legislation.
Oh.
Then the Rules Committee looks at it to see if it's a legal kind of thing to do. And then if they say okay, it goes to the floor. That's my understanding.
Okay.
Oh, and I do remember what I was gonna say, which is that Arizona doesn't have a year-round legislature. It ends in April. So that's why there's this deadline. Yes.
Now, I'm trying to think of some specific strategy that we can use in this room, since we got a week to go. Should we be still contacting them to, Ms. Fan, to see that she'll send it to another committee, or is that off the table?
I think that's off the table now, it sounds like, yeah. And our own legislators here are in favor of it, so you can contact them, but, you know, contact them and say, keep up the good work. Yeah, I mean, I don't have anything special to tell you other than use the request to speak and talk to the people that I listed on the different committees that were already in favor of ERA. Contact them, that maybe they can do something legislatively. They're the ones that would know the rules better than you or me. Holly.
I don't mean to disagree, but I do think making those contacts, even though we hold little to no help, because they do have to count the numbers of people who call and request to get these out for
Oh,
committee.
yeah. Did I say don't do it?
Yeah,
Oh.
or I interpreted it.
No,
that-
no, that's not what I understood.
Yeah,
I understood
but
you
it's
said-
not, it's hopeless, but, you know, the numbers increase this year and they'll increase next year, and if these
Right.
people wanna get elected,
Right. I think we do have to look for the future, and you know what, it's 100% certain that it's not gonna happen if nobody does anything.
Yeah.
Yes,
Is Myra gonna post her video then, where we can review what you put on there?
she's
It will
nodding
be-
her head yes.
It will be on Facebook probably by later tonight, and it will be on our A4A blog, a4a.org, or allianceforaction.org, probably sometime tomorrow.
Thank you.
Nancy?
Those slides that showed the names of people to contact in the committees, as well as the request, or how to make that request, can we get copies of those made available? That one, and then I think the next one. Yeah, those,
Yeah, that one would be very
could we
that
get,
was a good slide.
have access on A4A for those?
If you can send me a hard copy, I can put it up on our Facebook page.
A hard copy?
soft, you mean a soft copy?
Electronic copy.
Well, either way, I can take a hard copy and put it up, or I can take an electronic copy and put it up.
If somebody tells me what to do, I'll do it. You guys know me. I mean, when I first got my iPhone, it was on mute and I didn't understand it. It was a smartphone. I thought but the phone would tell me it's on mute. Oh, I can send you a text? Okay,
Just email it to her the way you emailed it to me.
email it, okay.
Okay.